Okay, thank you. Thank you everyone for joining. This is our third Industrial Relations webinar held in partnership with AI Group. And today's topic is Respect at Work, and Brooke is going to cover the new obligations to stop workplace sexual harassment. Eliminating workplace sexual harassment has been a focus for many businesses. And as part of the pre-election commitment to implement all outstanding recommendations of the Respect at Work report, the federal government has released two significant pieces of amendment legislation. This legislation introduces new legal frameworks impacting employer obligations and how workplace sexual harassment is prevented and addressed. But recent changes in workplace health and safety laws will also play a part in framing how employers are to prevent unlawful sexual harassment. Once again, we are joined by Brooke West, Senior Associate from AI Group Workplace Lawyers, who will present today's webinar. Welcome, Brooke. For those that missed the two previous webinars, the recorded webinars and all the fact sheets are available on the AUSVEG website. The next webinar is scheduled for the 4th of May, and we will send out further notification in a couple of weeks on that one. We will take questions at the end of today's sessions if there is time permitting, but please feel free to add any questions into the chat and we can make sure these are covered in any of the fact sheets. Thank you, and over to you, Brooke.
Thanks very much, Lucy. Thanks for everyone for joining us for briefing number 3. So as Lucy's just introduced today, we have a session on new legal obligations, as well as existing obligations on growers to prevent workplace sexual harassment. So we've progressively seen a lot of change in this area. So we're going to cover a variety of key areas. And the first of those is the Respect at Work Act, as well as visiting briefly the relevant changes which commenced through the Secure Jobs Better Pay Act. I will then talk through some recent case examples and cases, focusing on some case law that are relevant to the new employer obligations on a practical level. And then lastly, I will touch upon some really important work health and safety developments as sexual harassment extends beyond the Respect at Work and the Fair Work Act changes. And there are some important work health and safety provisions that growers need to be aware of, and I'll take you through those. So before we begin, I just do want to provide a bit of a content warning. Unfortunately, sexual harassment is something that many people have experienced either personally or they know or have supported someone who has experienced sexual harassment. And as I said, I am going to be talking about some cases in this area. So I did just want to advise those viewers joining us live on the webinar today and those who may be watching the recording at a later date that there will be some discussion of sexual harassment. So I just wanted to provide the opportunity for you to tune out at relevant times if you would prefer. But for the most part, I will be speaking about the technical aspects and the mechanics of these new laws and what they require growers to do. So the Human Rights Legislation Amendment Respect at Work Bill, or the Respect at Work Bill or Act, was passed in the same week as the Australian Human Rights Commission released its 5th national survey on sexual harassment in Australian workplaces. And that survey indicated that despite reforms in this area, 1 in 3 Australian workers experienced sexual harassment in the last 5 years. And we know that this is not just an issue for one gender. 16% of men also experience some form of workplace sexual harassment. So it affects both genders. I do just want to acknowledge here that the report is quite binary in terms of gender and it's not inclusive in terms of gender diversity. So I do apologise if any offence is caused by that limitation. Secondly, the prevalence is both high for private and public sector workplaces, so including parliamentary workplaces. Now, if you are a grower who employs a younger workforce, then unfortunately the statistics indicate that you are more likely to encounter cases of sexual harassment. So people 18 to 29 were more likely to experience workplace sexual harassment than any other age cohort. And that sexual harassers were often co-workers of victims. And in a majority of cases, those harassers had in fact engaged in harassment of others in a similar manner. The survey also reported that most common form of sexual harassment was, the innuendo, the jokes, suggestive comments. And I think that's really important to bear in mind if we're talking about cultural change, which is really what the Respect at Work reforms are trying to introduce into many businesses. It's also important to understand that sexual harassment is not just an event that occurs at social work functions, such as Christmas parties or out of work events involving alcohol. In fact, more than half instances occur at a victim's workstation or area of work, and is in fact witnessed by others. And we know that 40% of these cases were witnessed by at least one person. But interestingly, looking at the impact that bystanders can play, most witnesses to sexual harassment do not intervene, and presumably that's because they're either uncomfortable in doing so or potentially worried about the personal ramifications that might have. And importantly, a key takeaway from the survey is that fewer than 1 in 5 people who experience sexual harassment actually notify their employer about it. So if you are a grower who relies on a policy and or a grievance process as a mechanism of addressing sexual harassment, you will soon learn that mechanisms like that alone may not be enough to comply with the new legislation, because the new laws are very much around ensuring sexual harassment and unlawful discrimination but becomes far more of an employer's or grower's preventative duty under both Respect at Work, the Fair Work Act, and the Work Health Safety laws. So firstly, turning to the Respect at Work Act, it was introduced into Parliament late last year, so on the 27th of September 2022, and it, as Lucy introduced, it does represent the government's commitment to implement key outstanding recommendations from the Respect at Work report. So the bill passed both houses on the 28th of November 2022, and it was enacted at the end of last year on the 12th of December. So it's in force now. So I'm going to take you through some of the key high-level changes that you growers need to be aware of in terms of the Respect at Work Act. So firstly, it introduces a new provision into the Sex Discrimination Act that makes it unlawful for a person to subject another person to a workplace environment that is hostile on the grounds of sex. So this has a broad meaning, and it's addressing where the conduct occurring in a workplace where either the victim or the perpetrator works, the victim is in the workplace at the time the conduct occurs or afterwards, and a reasonable person having regard to all of the circumstances would have anticipated the possibility of the conduct being offensive, intimidating, or humiliating to a person of the sex of the person impacted by the conduct. So the Act sets out that in determining whether a person has subjected another person to a hostile work environment on the grounds of sex, it is necessary to consider the seriousness of the conduct, whether the conduct was continuous or repetitive, and the role, influence, or authority of the person engaging in the conduct. So this amendment really clarifies the law so that it is understood that sexual harassment may occur where a work environment or a culture is sexually charged or hostile, even when the relevant conduct is not directed at a particular person. Secondly, one of the more high-profile changes is this creation of a new statutory positive duty on employers or growers in the Sex Discrimination Act, and that requires growers, as either an employer or persons conducting a business or undertaking, so PCBUs for short, to take reasonable and proportionate measures to eliminate, as far as possible, unlawful sex discrimination, workplace harassment, and workplace harassment includes the broader definition of the hostile work environment and harassment on the grounds of sex, and then lastly as acts of victimisation. So the new positive duty means that growers will be required to move from just responding to the conduct in a reactive way, so something that has already occurred, to proactively taking steps to prevent that conduct from occurring in the first place. And I will be turning back to the positive duty in a bit more detail in a moment. So other changes concern empowering the Australian Human Rights Commission with an inquiry function in relation to a person's or business's compliance with a positive duty. Now, historically, the Human Rights Commission was more of a complaints body that attempted to resolve complaints received through mediation and conciliation between parties. But with these amendments, it now has specific powers to issue compliance notices and enter into enforceable undertakings, and then subsequently apply to the federal court to direct compliance by employers or growers if they have not complied with either an enforceable undertaking or a compliance notice. So we will see the Human Rights Commission in many ways exercising more of a regulator function, enforcing the positive duty against duty holders. The Human Rights Commission will also have a broad function to inquire into actual or systemic unlawful discrimination, and that is just defined to mean unlawful discrimination that affects a class or group of persons and is continuous, repetitive, or it forms a pattern. So there are other changes which will enable a representative body, so for example, a union, to progress a complaint on behalf of one or more persons from conciliation at the Australian Human Rights Commission to application to the federal courts. So these new Australian human rights, powers effectively will come in into effect on the 13th of December 2023. So that is giving growers a total period of 12 months to understand and begin to comply with the new positive duty obligations. So there are other less significant but nonetheless really important changes for growers to be aware of that are arising from the Respect at Work Act, and I will cover those briefly. Firstly, for context, in 2021, there was an amendment to the Sex Discrimination Act by the former government to include another limb of harassment on the grounds of sex. And this was based around conduct that was considered to be seriously demeaning in nature to the person harassed. Now, what the Respect at Work Act does is removes the word seriously. So in effect, it lowers that threshold of what is harassed on the grounds of sex. And so this is important for me to mention because growers, you may have amended your policies as a result of the changes that were made in 2021. So you may need to revisit those policies again to reflect these changes. We also see changes to the Sex Discrimination Act that will replace concepts of equality of opportunity in the objects of the Act to substantive equality between men and women. So this refers more to the outcomes of equality as a separate concept of equality of opportunity itself. There has also been changes to protections for persons covered by anti-discrimination more generally, specifically the victimisation offences that we see were already in the Sex Discrimination Act, but they have been extended to the Age Discrimination Act, the Disability Discrimination Act, and the Racial Discrimination Act. And then lastly, there's been a replacement of the 6-month limitation period for lodging complaints to the Australian Human Rights Commission. That's been extended to a period of 24 months. But I do note that the Human Rights Commission still has a broad discretion to allow a complaint beyond that period. So they are the key changes under the Respect at Work Act, but I wanted to explore in more detail this concept of the positive duty. Effectively, the obligation applies to conduct that is identified as unlawful under the Sex Discrimination Act. So that is sexual harassment. Again, that includes harassment on the grounds of sex and workplace hostile environment hostile on the grounds of sex, unlawful sex discrimination, and victimisation. So rather than just general inappropriate conduct towards an employee. And again, it will be enforced by the Australian Human Rights Commission, but not for a period of after 12 months. So again, on the 13th of December this year. So you do have effectively some time to establish processes and systems to demonstrate visibly to a third party that you are complying with the positive duty to eliminate workplace sexual harassment and discrimination. So the positive duty applies to employers and PCBUs or duty holders in respect of unlawful conduct engaged in by the duty holder itself, so you as an employer, a duty holder's employees, as well as workers if you're a PCBU. So not the direct employer, but you as a grower, for example, might engage labour hire workers. So your duty would also apply to you and those workers being a PCBU. And also your agents as a duty holder. So the duty extends to identified unlawful conduct towards employees and workers by other persons, and this does include third parties. So for businesses or growers who potentially might operate with customers or are customer facing, that extends to conduct by the general public or customers towards your employees or workers, such that it's that conduct that you would also need to manage to ensure as far as possible that workplace sexual harassment was eliminated in accordance with that positive duty. So it's quite broad, and you need to be thinking about your operations in terms of your obligations to your employees and workers. So ultimately, the Respect at Work amendments, unfortunately, again, as we saw in the Secure Jobs Better Pay Act, they don't identify specific action to be taken to comply with the positive duty. However, matters to be taken into account in assessing whether you as a grower has taken reasonable and proportionate measures to eliminate sexual harassment include the size and nature and circumstances of your business or your undertaking, your resources, financial or otherwise. So that's referring to, potentially your size, and often we'll see smaller employers don't have, a large HR department. So that's kind of talking about the resources there. The practicability and the cost of the steps to eliminate the conduct covered by the duty. And then lastly, abroad, any other relevant matter. So for those growers who are based in Victoria, this might look somewhat familiar to you because the positive duty in the Sex Discrimination Act is very much based on the terms of the positive duty, which is found in the Victorian Equal Opportunity Act. So what is the positive duty and what do you as an employer, does a grower need to do to satisfy this duty? As I mentioned, the Respect at Work Act changes don't articulate precisely what it is that you need to do. However, that will be made more clear. So there's a bit of comfort here. The Australian Human Rights Commission will prepare and publish guidelines for complying with the positive duty. And from that, we do expect to see some specific scenarios and suggested compliance action that employers and growers should be taking. Now, it is intended to align with Section 106 of the Sex Discrimination Act's vicarious liability defence of taking all reasonable steps to prevent the unlawful conduct, such that the steps taken to satisfy the positive duty should also assist you in demonstrating that you all took reasonable steps to prevent the unlawful conduct. And so that Section 106 is just on the screen there for you now for reference. However, while the explanatory memorandum does state that the positive duty is intended to align with the Sex Discrimination Act's vicarious liability defence, growers should not assume that the existing preventative measures that you have in place will be sufficient to comply with the new positive duty. So it's just really important to touch upon that. So again, whilst it's not specifically set out in the Sex Discrimination Act, the explanatory memorandum does give us some examples of different business scenarios as to what would be indicative of complying with the positive duty. So the first example we have here is Joe of a small delivery business. He has 8 employees and he writes a short policy on harassment and discrimination, including how a complaint would be handled, and also includes responding to inappropriate conduct by customers, recalling that third-party conduct towards your current workers is covered by that positive duty. So in this example, Joe doesn't just create a set and forget policy. He discusses the policy during a staff meeting. He provides printed copy to all staff and then goes further and regularly checks in with his staff to discuss rostering leave, but also behavioural issues. So as a result, the explanatory memorandum will indicate that Joe and his business is likely to be compliant with the positive duty expected for a small business. Secondly, we have a medium-sized business scenario. We have an employer operating a hotel in a ski resort with a workforce of largely casual and part-time employees. The business owners design and engage in a risk assessment process, which is an important concept, which I will talk about later. And as a part of that risk assessment, they identify that short-term work for employees is something that is needed to be addressed as a part of eliminating sexual harassment. So in order to do that, they develop an action plan for complying with the positive duty. And as a part of that plan, they task their HR officer or HR department with developing a policy on harassment and discrimination and ensuring that this is included in a part of the onboarding process for new staff. Additionally, they also require managers to complete externally provided training on harassment and discrimination on an annual basis. And then those managers are then responsible for ensuring their staff are aware of the policy and they reiterate the behavioural standards expected by that policy. So again, here we can see that reinforcement of the company's approach to preventing workplace harassment rather than just developing a policy and leaving it there to gather dust. And again, this is, the explanatory memorandum is saying that this is indicative of complying with the positive duty for a medium business. So that you can see that there's a slight increase in the level of expected measures that a larger business might be expected to take. Now, for those larger businesses, the next is an example of an IT employer who employs more than 250 staff working remotely and in small teams. So it's raising those challenges around visibility and supervision over people working in different locations. And that's whilst growers on the line today might not be considered large businesses, because of your remote locations and your employees, performing, growing, sorting in, isolated environments where there's not much supervision, this is something that you should be turning your mind to. In this case, we have Ben. He's responsible for implementing a strategic plan on harassment and discrimination, which includes confidential staff surveys, data collection on complaints and regular reviews of existing policies and procedures, mandatory training for managers and new staff on harassment and discrimination. Again, incorporating the risk assessment process, Ben also develops and circulates specific guidance on harassment and discrimination in a remote context, noting the risk there, and also details on the supports available to staff. So now this is, again, not prescriptive in any way, but it is giving an indicative example of what would be compliance with the positive duty for a larger organisation. And again, you can see that scaling up of the measures and the steps that are taking. The positive duty is very much to be built around what are your risk factors involved in your particular business and operations, and what is available to you to eliminate your workplace sexual harassment and discrimination risks. In addition to those changes that I've just discussed, growers might recall from our previous briefing, our first briefing, that there are also sexual harassment related changes in the Fair Work Act, which were implemented through the Fair Work Amendment Secure Jobs Better Pay Act. Now, to recap, the Secure Jobs Better Pay Act introduced new provisions such that sexual harassment is now also a prohibition in the Fair Work Act. So this, again, was one of the recommendations made by the Respect at Work report prepared by the Sex Discrimination Commissioner in relation to sexual harassment in Australian workplaces. So the sexual harassment prohibition is in connection with work and applies broadly to workers, prospective workers, and also persons conducting businesses or undertakings, again, PCBUs. So again, there is a broader coverage beyond just employees and the employer relationship. Importantly, for growers, you could be vicariously liable for the acts of your employees or agents if you cannot prove that you took all reasonable steps to prevent the conduct or the sexual harassment. So that's very similar to what is contained in the Sex Discrimination Act in terms of the vicarious liability defence. In addition to the new prohibition, the Fair Work Commission has a dispute resolution jurisdiction that will be extended not only to enable it to continue to make stop sexual harassment orders, which it currently has jurisdiction to do, and I'll talk about that in a little bit more detail shortly, but it also is able to deal with a dispute in relation to sexual harassment by conciliation or mediation. And if the dispute remains unsettled, parties can either agree to pursue the matter within the Fair Work Commission to consent arbitration. So they both have to agree to go to arbitration. And at that stage, the Fair Work Commission is empowered to make orders, and this could include payment of compensation. Alternatively, if the dispute does remain unsettled and the parties don't consent to arbitration, the Fair Work Commission will issue a certificate, and that will enable the applicant to make an application to the federal courts. And that, again, is similar to the way that our general protections laws operate at the moment. So an applicant would make a general protections claim, it would be in the Fair Work Commission, and if it's not settled, then it progresses to the courts through the means of a certificate. So again, these provisions commenced on the 6th of March 2023. So growers, in terms of further resources, growers are encouraged to visit the Respect at Work resource hub, and there's further information in this space. The Respect at Work Hub is a dedicated website to these changes, and it does provide a range of resources to prevent, address, and promote better understanding of workplace sexual harassment. This includes videos, advice, good practice guides, education and training programs, and working assessment tools. And this actually includes the Good Practice Indicators Framework for preventing and responding to workplace sexual harassment. So that includes intended outcomes outcomes and indicators of good practice for growers with respect to preventing and responding to sexual harassment. So the framework includes both simple and mature measurements, allowing growers of different sizes to assess their performance against each indicator. So it's encouraged that you go, you visit the website and have a look at all of those resources that are available to you, in addition to today's briefing and the material that we'll release shortly thereafter. In addition, and as a part of the Respect at Work amendments, the Australian Human Rights Commission has also been tasked with preparing and publishing guidelines for complying with the positive duty. So they are yet to be published, but growers are encouraged to visit the Australian Human Rights Commission for further resources and guidance, and just keep an eye out on the release of the guidelines in this space. And then lastly, the Fair Work Commission is also a great resource. They have a variety of resources and information available in relation to the sexual harassment in the Fair Work context. And I understand that they will be shortly releasing a bench book on sexual harassment. And that's a really good resource to understand really in a simple way how the law will operate. So now I'm just going to focus on discussing some cases that are relevant to the new obligations that I've just spoken to. So firstly, beginning with the recent Western Australian parliamentary inquiry into sexual harassment against women in the FIFO mining industry, the report, which is called Enough is Enough, it provided insight into what has been happening in FIFO workplaces, which really are the powerhouse of Western Australia's economy. FIFO workers are generally based in remote workplaces, and because they fly in and fly out, they're often on site for extended periods of time. So this does give rise to a working environment where the difference between work time and recreational time can be blurry. Synonymous with some of the grower operations that you might have with respect to live-in accommodation. So just be mindful of that. You may recall hearing about the report in the news and media, because some of the findings of this report were actually quite shocking. So I will just repeat my earlier content warning. If you would prefer not to listen to these examples, I'll give you a brief moment to mute me or shut me off. But the findings in the report basically included, in summary, a woman being rendered unconscious in a donga and waking to find her jeans and underpants around her ankles. We also had an offer to make a safety investigation go away in exchange or return for sex, and many other stories of unsolicited and unwelcome sexual attention, stalking, texting, and instances of sexual assault. So quite damning findings. The report found that women in the mining industry are frequently subjected to sexual harassment and sexual assault. And the report found that much of this unlawful and criminal behaviour was either being ignored or overlooked by employers who just had failed to act. So the Western Australian jurisdiction has generally accepted the recommendations in the report, but I just thought it was worth touching on this report today, because the systemic pattern of workplace behaviour described in this report is a good example of the types of matters that the Australian Human Rights Commission may inquire into using its broad inquiry functions that it has been given in the Respect at Work Act. So moving on to some specific case law, again, the Respect at Work Act introduces several changes to the Sex Discrimination Act and the Australian Human Rights Act, which I did cover earlier. And as I mentioned, it is unlawful for a person to subject another person to a workplace that is hostile on the grounds of sex. So this is a proposed change which actually clarifies what many courts had already found in relation to unlawful sexual harassment. And a good example of this is the Sydney Water Corp case. Excuse me. So in this case, the Sydney Water Corp and another employee displayed a poster at a Water Corp depot, which included a photograph of a female employee and a caption, a banner that read, "Feel great, lubricate." So The employee in the photograph was unsurprisingly humiliated by this conduct. She thought that she had been taking part in a campaign in relation to lifting and spine safety. And after the post was put up, she received a variety of email and text messages from colleagues that were making fun of her. And she claimed that the poster constituted sexual harassment. The court rejected Sydney Water Corp's arguments. They argued that unless the conduct in question is sexually explicit, it cannot amount to sexual harassment. So the court ultimately held that the employee being depicted in this, Sydney Water Corp was saying that the employee depicted in the poster did not constitute sexual harassment. So making it unlawful to subject a person to a workplace environment that is hostile on the grounds of sex means that conduct complained of does not necessarily have to be predatory or sexual advanced type of character that we often associate with sexual harassment claims. This case is a good example of how something like this can still be considered sexual harassment. And, you know, Sydney Water Corp's arguments were rejected by the court, and the applicant in this matter was actually compensated and awarded $200,000 worth of damages. So quite some significant money here at stake. As I've touched upon, under the previous government, changes were also made to the Fair Work Act in 2021 in relation to sexual harassment. And in addition to its recently expanded jurisdiction in respect of the sexual harassment matters, the Fair Work Commission does have the power to issue what we call stop sexual harassment orders as a part of its broader anti-bullying jurisdiction. So in this space, the Commission can make orders to stop sexual harassment at work where the sexual harassment happened at work and where there is a continued risk of the sexual harassment happening at work. So those changes also clarified that sexual harassment was also a valid reason for dismissal in relation to unfair dismissal claims, so something to be mindful of in terms of disciplinary processes for employees. Now, since this jurisdiction was enacted in 2021, there's only been 29 applications lodged in the 2021-2022 financial year. And of those, 5 applications were for an order to stop sexual harassment as a standalone, and 24 applications for an order to stop both bullying and sexual harassment. So the majority of these applications were discontinued early on in the case management process. The remainder of the applications were resolved or discontinued after a conference before a commission member. So to date, only 4 decisions have been issued by the Fair Work Commission, and in all of these decisions, the application has been dismissed. And basically on the basis that the application was incomplete, and in the majority of the other cases, it was on the basis that the order, that an order was not necessary to prevent future harm. So the Fair Work Commission was not able to make a stop sexual harassment order. So we will take a look at the second most substantive ruling in this jurisdiction, which was a ruling by Deputy President Beaumont. In this case, the Deputy President found that a supervisor did in fact sexually harass a casual chef. The sexual harassment occurred when he asked her to be his girlfriend, and when he phoned her and asked her to have sex with him. So in this case, there really was no issue in determining whether such conduct constituted sexual harassment. However, the employer's submission challenged the applicant's evidence on the basis that she was difficult to work with and had performance issues. This was ultimately rejected by the Deputy President. However, to make a stop sexual harassment order, the Fair Work Commission has to be satisfied that the applicant had been sexually harassed, which was the first threshold which was met. But there needs to be a risk that remains that the applicant would continue to be subjected to that conduct. And so during the proceedings, the applicant actually advised the Fair Work Commission that she had quit her job, which is understandable. But that meant that there was no longer a risk to her that she would be subject to further harassment. So the Deputy President did not have the power or the jurisdiction to make any stop sexual harassment order. So this is relevant to highlight, again, the changes in the Secure Jobs Better Pay Act. It's expanded the Fair Work Commission's power in relation to sexual harassment claims, in that it creates a new jurisdiction within the Fair Work Commission to deal with sexual harassment disputes and applications. And in exercising its jurisdiction, the Fair Work Commission may make a stop sexual harassment order but now they can also otherwise deal with the dispute. So had the Fair Work Act been amended at the time of this application, this option may have been available to the applicant in this case. She may have opted for the Fair Work Commission to deal with the dispute by way of mediation or conciliation, as opposed to by way of requesting a stop sexual harassment order, which again can only be ordered in the limited circumstances. And again, the Fair Work Act provides further that if the dispute is not resolved, the Fair Work Commission will issue a certificate, and that can either proceed to arbitration by consent, or it can progress to the federal court. So this may have also been an option for the applicant in this case, because now we have an applicant, does not actually have to be a current employee. An applicant may have up to 2 years to make an application after the alleged conduct. So lastly, I'm going to take the remaining time to talk about the work health and safety responsibilities, because it's really vital that growers understand that the Respect at Work amendments are not the only source of regulatory change impacting employer obligations to prevent and address workplace sexual harassment. And the Respect at Work amendments actually make it clear that the duties under work health and safety laws operate independently of the Sex Discrimination Act's positive duty. So this means that complying with the Sex Discrimination Act's positive duty and your duties under the Fair Work Act does not automatically result in you complying with your duties and obligations under the work health and safety laws. So the model WHS regulations were amended in 2022 to include a division addressing psychosocial hazards and risks. Sexual harassment has been identified as one of the 14 psychosocial risks contained in the Model Work and Health Safety Code. So it has been specifically called out as a risk that growers need to start engaging with. Now, we've always had obligations under health and safety laws, generally, or occupational health and safety laws, as is the case in Victoria, to eliminate or minimise risks so far as is reasonably practicable. And those obligations have always related both to the psychological risks and the physical risks. However, over recent times, there has been targeted efforts in increasing awareness around an employer's obligations for the psychosocial risks, with a specific focus on sexual harassment. So firstly, we saw this through specific guidance. So Safe Work Australia and the individual jurisdictions at the ground level began producing specific guidance material, and Safe Work Australia has done a lot of work on developing guidance material around sexual harassment. And then we started seeing the introductions of codes of practice. So codes of practice, provide the additional information as to how an employer or a grower can comply with the general duty or the requirement of the regulations or the laws. And some of the individual jurisdictions introduce codes ahead of a model code. And then lastly, the regulations were introduced. And so the regulations, give effect to the WHS laws. They prescribe the specific things that a duty holder must do to comply with a duty. So by way of background and context, the majority of states and territories adopted the original version of the model WHS laws, or work health and safety laws, which commenced in 2012. So these states and territories are what we refer to as harmonised jurisdictions. And Victoria is the only state that operates outside of the model work health and safety laws. They've maintained their own Occupational Health and Safety Act regulations and codes. So the laws implemented in the harmonised jurisdiction, they're mostly consistent with the model work health and safety laws. You will find that there are some slight variations, and that's to address local needs or maintain historical decisions of importance to that jurisdiction. So again, the model work health and safety laws and regulations were amended last year in 2022 to include that new division addressing the psychosocial risks and hazards, which includes the sexual harassment. However, any amendment to the model work health and safety laws only come into effect on the individual jurisdiction if the act or the regulations in that jurisdiction are amended to incorporate the change. So that's similar with the model codes of practice. They will come into effect if a jurisdiction formally accepts those codes. So there is nothing that compels jurisdictions to adopt the model work health and safety regulations or code of practice, specifically as they relate to the psychosocial health and safety. But on the screen there, I've just got a summary of the current state of play in respect of the transitioning of the psychosocial regulations. Most harmonised jurisdictions have adopted the model work health and safety regulations. However, some do have some minor amendments to the detail. Firstly, New South Wales have adopted the model work health and safety regulations with effect from the 1st of October last year. WA and Tasmania have also adopted the model regulations, both with effect from December last year. Queensland have adopted the model from the 1st of April this year, so only just this week, but is including a reference to the hierarchy of controls, and you'll see that shortly. And again, Victoria, going out on its own, it's the only non-harmonised jurisdiction, and they won't be adopting the regulations. They are currently developing their own regulations and codes, and draft regulations will put out for consultation in February last year. And following the outcome of the state election, the Victorian Government and WorkSafe Victoria are continuing stakeholder feedback, and they are progressing the proposed regulations, and that will continue throughout this year. And the remaining states and territories, so Northern Territory, South Australia and the ACT, have not yet made regulations for psychosocial risks. So the Model Code of Practice for Managing Psychosocial Risk was published on the 1st of August 2022. And that is designed to provide guidance, again, on how to comply with the model WHS laws, including the new amended regulations relating to psychosocial risks and sexual harassment. So in relation to codes, New South Wales and Queensland have published their own psychosocial risks. They are not going to be adopting the model code, although they have a lot of similarities. They basically identify the same psychosocial risks and the same sorts of controls. However, New South Wales didn't actually want to wait for the release of the model, so they published theirs quite a while ago, back in May 2021. We also have WA, they have a code on psychosocial risks generally, and then also specifically on workplace behaviour, which encompasses sexual harassment. And Tasmania have adopted the code from January this year. And again, Victoria, they're going out on their own, and they will do their own code based on their finalised regulations once they're complete. So the key thing to emphasise here as a starting point is that the health and safety legislation requires an employer to eliminate or minimise risks so far as reasonably practicable, or in Victoria, reduce the risk as far as is reasonably practicable. So when we come to the psychosocial regulations, which I will put up on in the next slide, the next slide does contain a lot of text, and I really don't want you to focus on all of the words. However, I will direct your attention to the words that are bolded and underlined. So the slide on the screen now shows you the model work health and safety regulations on the left and the Victorian draft regulations on the right, as it relates to what an employer or a grower must have regard to in determining control measures. And what is highlighted there is the difference, is the reference to information, training, instruction and supervision. So you will see in the model work health and safety regs, right down the bottom there, that in determining the control measures to implement, a person may have regard to, amongst other things in that list, the information, training, instruction and supervision provided to workers. And its placement at the bottom there indicates or signals that that's really a lower level of control. However, you can see in the Victorian legislation regulations on the right, as it's currently drafted, it's much stronger, and it specifically provides that you may not rely exclusively on information, instruction or training as a control measure unless you have considered all of the other control measures, and none of those are reasonably practicable to implement. And then secondly, that the information, instruction or training cannot be the predominant control measure. So it can't be the only one that you're implementing to minimise your risk. So that's really important to note, because the scenarios that have been used in the explanatory memorandum in relation to the Respect at Work Act obligations, which I discussed earlier, insofar as they suggest that relying heavily on the use of policies and procedures and training directly related to sexual harassment could be indicative of compliance in the Respect at Work context. Here you can see in the health and safety law context, you need to have regard to several other areas of control and higher levels of control. And so not just focusing or relying solely on the information and training as a measure, which you can see here is considered to be a lower level control. So again, whilst it might be considered a measure of securing compliance in the Respect at Work context, as a standalone measure, it is unlikely to be sufficient when it comes to compliance with the work health and safety law obligation. So that there is just an example of what I was talking about earlier on in the webinar around, you know, relying on your Respect at Work obligations might not be enough in terms of your other obligations in other jurisdictions, such as the work health and safety. So once again, focusing on the text that is bolded and underlined, in determining the control measures to implement, the model laws provide that a person must have regard to matters including the design of work, including job demand and tasks, systems of work, including how work is managed, organised and supported, the design and layout and the environment conditions of the workplace. And the Victorian regulations, again, they have a very similar approach. So the management of work, systems of work, work design, or the workplace environment. So what you can see here that it is very much about considering and having regard to you as a grower. How do you do the work? And in doing that work, are you creating hazards that may lead to an increased likelihood of sexual harassment in the workplace? Those are the things that these regulations are asking you to do. Queensland has a particular reference to the hierarchy of controls. You might recall that I referenced that earlier. So the hierarchy of control is a step-by-step approach to eliminating or reducing risks, and it ranks risk controls from the highest level of protection and reliability through to the lowest and the least reliable protection. So the hierarchy of control first instructs growers to eliminate hazards and risks. If employers cannot eliminate that hazard and risk, then they must work through that hierarchy of the selected controls that most effectively reduce that risk. I have just reproduced it there on the slide there as a reference point. So it's important to note that the model work health and safety regulations do not have a hierarchy of controls, and it has been excluded from Tasmania, Western Australia and the New South Wales model work health and safety regulations. So it doesn't really make a difference between how Queensland growers are expected to manage their sexual harassment in the workplace and how our growers in other states are going to. Put simply, no. So the decision to exclude the hierarchy from the model regulation was not intended to allow for a lower level control to be acceptable controls for the psychosocial risks, but rather during the finalisation process, there was a majority view that whilst it was important to apply those higher order controls for psychosocial risks, you know, for example, that is not to rely solely on your training or other administrative controls. There was also a majority view that some of the description used in the hierarchy for the physical risks, they didn't quite translate to the work for the psychosocial risks. So it was left out. But in their code, Queensland utilised the same controls. They just list them differently and they allocate them to one of these categories on the screen there. So in practice, it is unlikely that the general approach to managing your psychosocial risk will vary between the jurisdictions that do or do not include these hierarchy controls. In both situations, growers will be expected to apply the highest level of control that are reasonably practicable. And then the administrative controls, you know, such as the training, can only be used and relied on when you've implemented everything else that you possibly can, and that risk still remains. So turning to the risk management approach that we need to use in the health and safety when we're dealing with sexual harassment as a psychosocial risk. I have two diagrams there on the slide for you. The one on the left is the standard diagram that's used in all of the codes and in the model laws, and it's based on a diagram that was in the Victorian legislation. So they have a very similar diagram. On the other hand, Western Australia has developed one that is slightly different. The only difference there is you can see in that middle circle, management commitment is the general approach, whereas Western Australia has included leadership, commitment, supportive and capable management and supervision. So you'll see the circle is surrounded by consultation and communication, and consult in the case of WA. And that's really a crucial part of all of our risk management in health and safety, particularly important for psychosocial risks as well. So making sure that we're getting the information from our employees or workers about what is actually creating the risks in the workplace that you as the grower may not be aware of. And then following that risk management process, which commences with identifying the hazards. So what are the things that you have in your workplace that might be increasing that risk of sexual harassment occurring? And again, for example, the work that is isolated or in remote locations. So sexual harassment that occurs that won't have any witnesses because there are no observers to moderate that poor behaviour. Poor understanding by workplace leaders of the nature and drivers and impacts of sexual harassment and power imbalances, those things, for example, and then assessing the risk and then implementing those control measures to eliminate or minimise that risk so far as is reasonably practicable. So in terms of the risk controls that are in the model work and health and safety codes, sexual harassment falls under a broad category of harmful behaviours. So harmful behaviours covering bullying, violence, aggression, and sexual harassment. So the control measures focus first very much on the physical work environment and security. So what are the things or controls in the physical environment that might actually reduce the risk of sexual harassment? So one thing which is a high level, high profile control is visibility, which includes improving something that we call natural surveillance in areas such as, public spaces, offices, storerooms, other segregated areas. So what are people seeing when they're in the workplace? And a classic example, and not overly relevant to growers, but a classic example is if you have an office with glass walls or semi-opaque screens instead of completely enclosed offices. It's that kind of thing that we're talking about. Things such as security, so implementing CCTV surveillance in areas where you might not have that visibility on the ground, providing that additional layer of visibility for you as an employer in those remote locations. Things such as lighting, the ability of people to have privacy when they need it. So giving employees the opportunity with a safe place to retreat or to easily move away from an environment where they might not feel comfortable, and whether that be with a co-worker or with someone in the public who might be exhibiting unreasonable behaviours. All of these things are built in as a part of your physical environment control measure. We then work into safe work systems and procedures. And so there's a range of those things which you think of within that normal context of how we would be highlighting the importance of sexual harassment as inappropriate workplace behaviour. So, for example, the clear communication strategies of behavioural expectations in the workplace, procedures and processes in relation to how sexual harassment is managed if it occurs, and then the information and training to prevent it. Excuse me. But there are other procedures that that you as growers should be considering in the design of work or the management of the work context that could reduce the risk of sexual harassment. So if you think of sexual harassment being a power tool within an organisation, then things like how is promotion managed? If one person has control over who is going to be promoted, providing overtime, days off, those kinds of things, and that person happens to be a perpetrator of sexual harassment, that person has really been given a lot of power to utilize that as a weapon. So whereas if you have a more transparent approach, and whether that be, again, promotion or allocation of overtime, rosters, days off, etc., all of those types of things, transparency in your procedures about how you do your work, how you manage the work, and making sure you have good performance management processes in place so they aren't being misused. They're the sorts of things that we're talking about in relation to procedures in the health and safety context. We're talking about those sorts of procedures first, and then the procedure around how we deal with sexual harassment if it occurs, or the training to prevent it. They are really the secondary procedures and training that we're talking about when we're looking at it from a health and safety perspective. Now, there's a lot of information that I could go through. However, the intent for me today was really just to highlight that there really is a different level of depth required when you're thinking about health and safety approaches to prevent sexual harassment and other workplace behaviours. You can see there that there's probably more things that you need to be doing in the work health and safety when we're looking at it as a comparator to the workplace, the Fair Work Act and the Sex at Respect at Work changes. The last thing I will be covering today in the work health and safety context is just the centre column there on the table on the slide. And that is what can occur in the compliance and enforcement in relation to the work health and safety laws. So I have covered what can happen in the Respect at Work and what can happen in the Fair Work Act. But in the work health and safety context, firstly, elected health and safety reps, if you have them, they can issue a provisional improvement notice in relation to anything where they believe you as a grower, an employer, is in breach of the health and safety laws. And then what you will have to do is you either have to comply with that notice, or if you disagree with the notice, you actually have an option to have an inspector review that notice within 7 days, but you need to do either one of those things. Secondly, health inspectors, work health and safety inspectors rather, could come in either as a part of a general visit or in response to a specific complaint, and they can issue an improvement notice or a prohibition notice. And when we look at that, they aren't going to investigate an individual complaint of sexual harassment, but what they would be responding to, they would be coming in and assessing what you have done as a grower to eliminate or minimize the risk that sexual harassment will occur in your workplace. And so they won't just be looking, again, at your policies and procedures directly related to sexual harassment. They'll really be looking at that design and that management of work that we've just spoken about. And then lastly, ultimately, if it is a significant breach, the regulator can actually initiate criminal prosecutions, and there are significant penalties associated with that. So really important that you're aware of your obligations and that you're doing all of the things that you should be doing to comply with your obligations. So I appreciate that I have provided you all with a lot of information to digest today. But the snapshot view is that growers effectively have a preventative and compliance and enforcement framework in this space, which is really built around the 3 jurisdictions. And so that's the human rights jurisdiction, so the Respect at Work, your work health and safety, and the Fair Work Act. So it's really important that growers are aware of the different requirements and obligations of each. And I've just been through those very briefly. And although there may be some level of overlap, you can see that there's level of overlap in terms of the language that's used in terms of, preventing or doing all that is reasonably practicable. It's vital to ensure that your response and measures in place in respect of preventing sexual harassment in the workplace are appropriate and compliant with all 3 frameworks in the jurisdiction. So again, looking back to the Respect at Work scenario, whilst those examples indicate that an employer might be considered to be compliant with the positive duty obligations under the Sex Discrimination Act, those examples don't really go into that more in-depth assessment that we've just spoken about that's required by the work health and safety laws. And again, by only implementing measures such as those training policies, the lower level mechanisms to meet your positive duty under the Sex Discrimination Act, growers are almost guaranteeing that they won't be meeting their obligations under health and safety laws. So to ensure compliance with the duty to eliminate or minimise the risk of sexual harassment, growers might consider undertaking a health and safety risk assessment to understand the factors and their exposure points in your organisation or in your operations that are increasing the risk of your sexual harassment in the workplace. Again, if you identify those risks, assess what is reasonable and practicable steps or the control measures that you can implement or take within the context of your operations to address those risks and implement them. Again, reviewing and updating policies dealing with sexual harassment, lower level control, but really important. Providing training about sexual harassment and the positive duty. And training could be conducted for all staff, but it could also be tailored to different groups. For example, executives in your organisation, supervisors, human resources if you have them, and managers and supervisors, and then a different one for frontline employees. So the employees on the ground, their level of understanding and their obligations will be very largely the same, but they will be different. So the level of training might be tailored and targeted to your different workforce and their responsibilities within your organization. Lastly, you should be considering about, a complaints and grievance handling framework in place to deal with and manage reports of sexual harassment. So really getting that culture change embedding within your organization, that people can come out and they can speak, and there is a safe space for them to make complaints about sexual harassment. And this includes personally or whether they've seen it. And then again, encouraging or requiring employees to make reports if they experience or witness or hear about it, and speak up about the key risks in the business. So you really want to be getting the cooperation of your employees to tell you where those risks are, what you can't see, but they can see, really getting that consultation in, really understanding where your risk points are. And your employees are the best people to be able to assist you in doing that. They do the work, they're on the ground, they can identify those areas which are exposing you in terms of your sexual harassment risks. So they really are just high-level recommendations, but the key takeaway is that growers really should aim to have a consolidated preventative framework, and that is capable of speaking to all 3 jurisdictions. So again, not just focusing on one area, for example. This will require looking at what elements you need to do to meet in each jurisdiction, and then implementing those measures and controls. So that concludes today's session. I hope everyone has learned something new, or if you didn't learn something new, it's been a good refresher. I think we've got a new presentation briefing in next month, Lucy, on the...
we've got right of entry and a few other different things that we're looking at. Yes,
so we're still not yet finalised. There are some things happening again in this space. We've got some recent developments happening in the industrial relations space. It's not slowing down. So we will provide some further information and updates in respect of the topics to be covered in our next briefing next month. So thanks everyone for tuning in and joining us today.
Thank you, Brooke. Once again, lots of information in there, and we do appreciate how much depth you go into. For those watching the webinar, it will be available shortly and with the accompanying fact sheet. So we look forward to the next webinar, which will be in May. Thank you, everyone. Thank you, Brooke.
Thanks, everyone.